number 40, Trustees of Columbia University versus D'Agostino Supermarkets, Inc. Let's give counsel a moment to exit the courtroom.
Morning.
Good morning, counsel.
May I reserve 3 minutes for rebuttal, please, Your Honor?
3 minutes, did
Yes,
you say?
please.
Yes, sir.
May it please the Court, my name is Evan Krinick, and I'm here today on behalf of Columbia University. Columbia is entitled to the benefit of its bargain for 3 separate reasons. First, this was an agreement negotiated by sophisticated parties represented by counsel.
Well, the real question is whether or not the damages that you came up with are a penalty.
Well, here's why it's not a penalty.
Given that the focus is the breach of the surrender agreement, the lease no longer exists. That's been terminated.
The lease has been terminated, but certain of its terms survived in the settlement or surrender agreement. But here's why it's not a penalty. A penalty requires proof of one of 2 things. Either the amount of the actual damages were capable of precise measurement when the agreement was executed, or that the sum provided in the agreement was grossly disproportionate to the actual damages. So we can look at those one at a time. When we executed the settlement agreement, surrender agreement, I just call it the agreement, we did not have a signed, sealed, delivered, executed lease with a new tenant. We didn't know what the terms of that lease would be. We didn't know the amount of rent that we'd be charging. We didn't know the amount
Columbia University owns a lot of real estate. Certainly, you all had a sense of the real estate market at the time. It's unfathomable to me that you have no clue as to what's ascertainable. In any event, you came up with some number.
Well, again...
The number can't be a penalty so far afield, right?
Well, we'll get to the gross disproportionate.
Okay.
I don't think it's that much afield. But listen, if anything it teaches us this year, between March 1 and April 1 of this year, 1 month passed, and the real estate market changed dramatically. Until you have a signed lease.
But that's in the middle of the coronavirus. That's sort of not the same situation.
Clearly not, Your Honor. My point is that until you have a signed lease, you can't with precise measurement know the precise amount of your damages. The parties are allowed to estimate what those damages might be if they can't precisely measure it at the time. We didn't know if it would take a month to get a lease.
At the time, you were pretty close to having the terms worked out with H-Mart, no?
Well, the record does not support that. The record supports that we were showing the premises to various tenants and that there were tenants interested. And I'm sure you can infer that we were in negotiations with the tenant. There's no hearing, there's no evidence, there's no testimony about that. That's all inferred from certain emails. But I'm not going to dispute the fact that Columbia is sophisticated. They weren't waiting for them to vacate before we looked for tenants, and we were showing their property to tenants. But a negotiation's a negotiation, and we did not have a signed lease. And until we knew how much free rent, how much tenant improvement dollars, what the rent was going to be, we can't say with precise measurement we knew exactly what our damages would be. So the parties
Is that
allowed
what's required? Exact precision?
precise measurement, I believe, is a test of this court.
And you wouldn't know that until the end of the term of the original lease, would you?
I think we
I mean,
would.
is it possible to ever know that until the first lease the term is concluded?
Yes, and here's
How?
the way I think.
How do you know that the new tenant isn't going to breach that lease?
Well, we don't know that at the time we execute the settlement agreement, but we do know that we have an estimate as to what those actual damages are. We know the estimate equals $1.2 million.
Okay, so we're talking estimate, not precise damages.
Right, but
That's my point. Okay.
Yes, but we take the estimate.
Well, you certainly could have chosen not to release them, right?
sorry, Judge?
And look, you could have chosen not to release them, not to terminate the lease, continue to hold them liable for that tenancy until you found a new tenant. You could have done that. You didn't. You entered a surrender agreement. You've terminated the lease. And now, again, what we have to decide is whether or not the damages provision you came up with rises to the level of constituting a penalty.
Right,
No one, I don't think, would be in disagreement that you're entitled to be properly compensated.
The analysis for liquidated damages, we take the amount of the estimated damages, which we know when we fix it at the future rent is $1.2 million. And the question is that grossly disproportionate? And the question is, to what? I think the appellate division applied the wrong benchmark. They took the discounted amount that we agreed to accept in this deal and said we have to compare the estimated damages to the discounted amount.
You essentially made your liquidated damages be based on what the damages, what you could have obtained under the lease, right?
We made the liquidated damages a formula at $1.2 million, and we need to compare that to what our actual damages were. And our actual damages have nothing to do with the new lease. As soon as the new lease starts, we're no longer damaged. We've never claimed damages based on the new lease. Our actual damages are the rent that we agreed to accept and the cost of procuring a new tenant, the broker's fees, the attorney's fees, the free rent, the tenant improvement dollars. And in the record, we added up.
You actually could have had damages under a new lease because you might not have gotten the same rent. I mean, you could have made that analysis. I understand.
But we haven't.
Yeah, I don't understand you didn't, and that's
Right.
not what we're talking about. But all right, correct me. Perhaps I've misunderstood the surrender agreement. As I read that damages provision, what you basically did was you got to retake the premises because they surrendered the premises. So you have the premises back to, as you agree, relet to a new tenant. And you were trying, if they breached, if they defaulted on the surrender agreement, to then get all of the rent you would have had if they stayed as your tenant.
Your Honor, I think that's not our argument, and let me see if I can explain why.
No, I'm just asking you, did I misread the surrender agreement damages?
Surrender agreement would provide us the damages equal to $1.2 million, which is the amount of the future rent.
Right.
The question
If they had stayed in possession, you didn't enter a surrender agreement, that would have been what you could have gone to court and gotten from them because they signed off on a lease, and if they're in default, they've got to pay it, right? You
Right.
would have had an
It was a good
action.
deal for
Whether you
them.
could collect is another story.
Yes.
But so, as I understood, I'm just trying to clarify. If I'm wrong, I want to be corrected. I understood the damages to get you all of the rent that they would pay if they had not surrendered this lease and not returned the premises to you, or let you regain the premises, and you also got the premises and the opportunity to relet and the opportunity to collect rent for the same period that they, right, the damages was imposing rent on them.
The amount, the amount that we're entitled to under the agreement
Yeah.
equals the future rent.
Yes,
If we had
correct.
never rented the premises,
Right.
then we would have been made whole.
Right.
But if they had not breached, we took the entire risk of the vacancy. If we did not relet the premises and they did not breach and pay the discounted amount, then we would have had that as our loss. We never would have recovered any money. But when they breached,
Can I ask
That's
you
not a
then?
surrender agreement.
it's a settlement agreement.
Yeah, that's
They're already in default. They owed us $270,000. Rather than sue them for that, we entered into this agreement. We took some risks that we wouldn't be able to relet the premises. They took the risk that if they breached, then they were going to be liable for more damages. That discounted amount is gone. Once they breach, it's off the table. It's not in the game anymore. They breach. They don't get the discount, breach, and still pay the discount. Who would ever make that deal? What landlord would ever make that deal ever again? Oh, we'll give you a discounted amount if you pay promptly, and if you don't pay promptly, you still just pay the discounted amount.
The landlord who's going to make that deal is the landlord who thinks this tenant is going to default throughout, I can relet, I can get a better tenant where I can continue to collect, and I'm going to get a payout from them for a good amount of money. That's the landlord who's going to enter that agreement.
Well, hindsight tells us it was a good deal for the landlord. Hindsight tells us they breached and it was a bad deal for the tenant, but a bad deal does not turn an enforceable
Yeah, but
agreement into a penalty.
I'm sorry, aren't they liable for all the money that you would have been due under the surrender agreement if they had not breached? You're getting all the money you wanted under that surrender agreement. You're getting
No.
your bargain,
They're
and
not-
you got the premises.
They're not liable anymore for the back rent that they agreed to pay. They're not liable for
Well, that's the point of terminating the lease.
They're not liable for that. They're not liable for the attorney's fees, which they're liable for under the lease. They're not liable for the broker's fees, which they're liable for under the lease. Both parties had good and bad here going into the deal. At the date we signed this deal, both sides had benefits, both sides had risk. But I go back to the question of gross, if I can, Judge,
Yes,
finish this
please.
point. It's grossly disproportionate. The $1.2 million is the number. It is the future rent, but that's the number. And the question is that grossly disproportionate to what we were entitled to based on the breach? It's
Can I
not
ask
limited
Judge,
to-
can I stop you there?
Yes.
Judge, is it all right if I?
Yes, of course.
I see the red light's on. The appellate division decision said that the amount claimed was 7.5 times what Columbia would have received if the surrender agreement had been fully performed. You remember that in the decision?
Yes.
Comment on it?
Well, we're entitled to recover not just the damages from the surrender agreement, but also the damages from the breach.
Is that math correct?
I'm sorry. Judge.
Is the math correct? It's the math.
If you're comparing the amount of the past rent, that was a discounted amount in the settlement agreement versus the amount of the $1.2 million, I believe the math is correct. But my point is the benchmark that they're making the comparison with is incorrect.
A different way to look at that 7.5 times number is that's how good the deal was for D'Agostino.
It would have been had they paid the payments in a
Right.
timely fashion that they were required to do. But I think the benchmark here, I keep going back to that, because the comparison between the $1.2 million is not the $170,000 they owe. That's a discounted amount. The comparison is between that and what we could have sued them for. If we had walked in, this is not the future rent, if we had walked in and said, you know what, we're going to sue you for the full amount of your damages, and it's in the record, and there should be a hearing on it if there's any dispute as to the numbers. There hasn't been a hearing on that, but it totals up to $750,000, what we could have sued you for. So if you don't breach, pay us $171. But if you do breach, you don't just pay us $171. What's the consequence then of a breach? Then you got to pay us our full damages, which would be about $750, which is not grossly disproportionate to the 1.2 in the agreement. That's why it's not a penalty. The 1.2 in the agreement is the future rent, and if we had never rented it, that would have been equal to our future damages. But the question is whether our damages are 1.2.
You're forgetting in that analysis that you got also the premises that you could relet, and you seem to not want to recognize that in this argument.
Well,
But that's your big benefit, that you got the property back and you could relet it.
Judge, it turned out to be a benefit. I'm not going to dispute that, but at the time we signed the agreement, at the end of May, it was a risk. It was a risk we were willing to take. A smart landlord obviously would take that risk, but we can't say with certainty that we were going to re-rent.
It's hard to see that as a risk considering the choice property we're talking about.
Well, I think it's a risk of vacancy, but the tenant got benefits too. They walked away from it. $1.2 million of potential liability, got to pay $260,000 that they already owed us. They have to have some consequences.
Sure, the most compelling deal is the one where both sides see a value to it. I don't disagree, you're right.
But there has to be consequences to their breach. The appellate division said, that's what you agreed to accept, now you got to accept it with interest. We're not a bank. We didn't make a loan. That wasn't the deal we made. Pay us whenever you want. What if they paid us 2 years later? Would that be okay? Here, they paid us 6 months late. Could they paid us 3 years later and just added interest? And that's not the deal we made. My point is the courts should not be interfering in this situation. This is sophisticated parties made a deal that they both thought was in their best interest. It was a settlement of a potential litigation. It was a settlement of a lease obligation. This court ought to back off and let the parties manage their own affairs, settle their litigation, come to a fair agreement that they both sign, and should not be stepping in to reset the parties' deal.
Thank you, counsel. Counsel?
May it please the court. Bruce H. Letterman for the respondent, D'Agostino Supermarkets. Before I get to the remarks I prepared, I want to follow up on what Judge Rivera pointed out. There's a fundamental flaw in what's being said here. If there were no surrender agreement, just D'Agostino shut the doors, let itself get sued, mailed the keys back, and the premises were re-rented, the law of mitigation of damages would apply, and they would not get all the rent. The statement over and over that they're just getting what they're entitled to is absolutely not correct, because as Judge Rivera was pointing out, they got back the premises, and if there were no surrender agreement, and like I said, they just walked out, mailed the keys, Columbia re-rented it, I submit what you'd have here is a case of no damages.
And as I understood it, the lease didn't require them to mitigate their damages, but that's not what I want to talk about. What is it that you lost in this deal?
This was a win-win for everybody. D'Agostino's had a store on Broadway by Columbia University with a lease which was below market because it was signed in 2002, right after 9/11, with modest escalations. And
There's something troublesome to thinking that you can breach a contract, a lease, that calls for, many hundreds of thousands of dollars of payments, and enter into an agreement, a surrender agreement that says, okay, we can't pay you, but we'll agree to pay you this if you let us off the hook. And then they say, okay, we'll let you off the hook if you pay this. If you don't pay this, then you're not off the hook. So, and then you don't pay that either.
well, that's,
So what, I don't understand what the nature of that agreement is,
the nature of that agreement, and that's the whole point, and although counsel said it's called an agreement, not a surrender agreement, if you turn page 105, it's called a surrender agreement. And the whole point of the surrender agreement was that they would accept $175,000 of future payouts, and there was
within
a
a
clause.
particular period of time.
Yes.
Look, if at the time you believed to a certainty the property was going to be re-rented, you wouldn't enter into that agreement at all, right? Because your damages, as you started out saying, would have been next to zero. New tenant would be right in there. They'd have to mitigate. And the reason you entered in the agreement was because you didn't know that. And the two parties agreed to allocate the risk by the surrender agreement. Isn't that what happened?
Any time, Your Honor, that there's a question of liquidated damages, somebody is necessarily challenging whether something that was agreed to was at the time an unreasonable penalty
But this
or a
isn't
reasonable
a
estimate.
plain vanilla liquidated damages provision. This is if, for example, the liquidated damage provision here said $5 million, I think we would then be in the world you're talking about. But to Judge Stein's point, if the liquidated damages are no more than the contract damages on the original lease, how can that be, in these sorts of circumstances, unconscionable?
Because at the time the agreement was signed, there was knowledge on both sides that that there was another tenant in the offing, and the clause did not provide.
But then you
did not
shouldn't have
contemplate
signed.
that.
Then you shouldn't have signed. You should have counted on the fact the new tenant would come in and your damages would have been a few $100s.
Well, as I said, Your Honor, every case involving liquidated damages, going back to cases by Chief Judge Marshall of the United States in 1822, cases by this court in 1868, 1910, 1997, 2005, every case which involves liquidated damages raises that fundamental question that somebody is looking back and challenging it. And in fact, the rules of liquidated damages, which are part of the Bar Association, are in cases were discussed by Judge Rivera in 2014, are in the Restatement of Contracts, and in fact have been legislatively adopted in the Uniform Commercial Code, has a formulation that the court must make a decision whether it's oppressive and whether it was something reasonably capable of estimation.
Counsel, could they have sued on the original lease after this breach?
No. And I think
They couldn't.
they couldn't,
They couldn't
because
elect
if you
to go
look at
on
the
the-
surrender agreement, on page 106 of the record, it says it's extinguished, terminated, over.
So why isn't the measure of whether this is a penalty compared to, this isn't in the record, what they would have received had they been able to sue under the lease?
Because that's a decision they made. There are a multitude of other types of contracts, as Judge Rivera pointed out. They might have had a contract, and right now in this age of COVID, they're being done all over the city saying, we will make a good faith effort to release, but you're going to stay responsible for the rent. There are contracts, which I've seen many, which talk about recovering discounted values, but it was a decision that Columbia made. Columbia was represented by Proskauer in drafting it. There are many contracts which turn out, for one reason or the other, to be unenforceable.
Can I just clarify something? Under the surrender agreement, under its terms, was D'Agostino's supermarket still liable for the back rent it owed, or was all of that extinguished?
No, it was liable for the back rent. That was the balance of $261,000.
That's what I thought. When he said that you were liable, because I read the surrender agreement to mean that it did not extinguish any back due rent.
No, the back due rent was the $175,000. Remember, what you had here was a payout. 11 payments. There was a default. We're not disputing that. After the sixth payment was due, the full 175 was tendered. They rejected it. I'm not saying they had to accept it, but they made a decision to reject the full amount before it was even due. And I submit here the analysis of Judge Scarpulin, the unanimously affirmed by the appellate division, is exactly the law of liquidated damages. This is
I'm
a
sorry, just to be
textbook
clear, that
case.
last point, you're saying you tendered the remainder that was due under the surrender agreement before the last payment date? Is that what you're
Correct.
saying?
The document, the lease called for 11 payments of $15,000 each. That's how you get to the $175,000. The payments would have gone through the summer of 2017. On December 30th, a check, it's in the record, was delivered for $175,000, which was the 6 late payments, plus another payment, plus the future payments. That was rejected. So, just on an equitable ground here, that was, kind of that was their decision.
Yes.
And what comes up in this case is Columbia has chosen to pursue a path of aggressively seeking $1.3 million. It's $100,000 plus $290,000 of rent plus water charges, saying that we turned down the 175, now we want 1.3 million, which really with interest is now 1.5 million. This has all the hallmarks of an improper liquidated damage clause. And again, unless this court is prepared to change the law, what has been the common law going back to England, under any analysis of liquidated damages on the two prongs that either it's something not capable of calculation or it's oppressive, it's a disjunctive test, I submit this court must
May I
affirm.
ask, is it your position that the appellate division, I know it's a short writing, but is it did they make a factual determination that the damages were ascertainable? Is that a factual determination or a determination on the law?
In my view, it's a mixed, upon analysis, it's a mixed question of law and fact, which constitutionally is beyond the power of this court, at least as I read Carter's on Court of Appeals practice to review. That in making that decision, both Judge Scarpula in a well-reasoned decision and the appellate division in a short, but there was a lengthy oral argument which you can actually watch online, they were fully aware. Using your words, Judge Rivera, the court, it's a issue of fact taking due consideration of the nature of the contract and the circumstances. And in making that determination, by definition, the appellate division and the court and Judge Scarpula made at least mixed findings of law and fact, which, as I read it, are beyond the power of this court, unless this court wants to adopt, which I submit would be a terrible result of their analysis, which is basically a wrong syllogism. If you're a business person, if you have a lawyer, no matter how onerous it is, it's enforceable. That's never been the law. There are many situations where, for one reason or the other, the courts have it. And the factors they raise are factors which a court can consider. The court, Judge Scarpula, was well aware that there was counsel. She considered it. This was brought up in the appellate division if you look at the argument online. So the courts below did exactly what this court, for 150 years, has been telling Supreme Court judges to do, analyze these factors, and come to a conclusion. And I submit, unless this court wants to change the law, it shouldn't. If I could have, I'd like to end with just a short anecdote, which I think you'll enjoy, and honestly, I knew this before we came in here. According to the New York Times, in 2016, Justice Ruth Bader Ginsburg went to Venice to watch her grandson perform in The Merchant of Venice. And according to the New York Times, and I think this is just a nice story, she was asked to judge an appellate moot court argument of the issues raised by The Merchant of Venice. And the question was asked to her, shouldn't the courts enforce a contract? It was a wealthy merchant from Venice who made a contract for a pound of flesh. And there were other issues, but as reported in the paper, Justice Ginsburg said, this is all merry sport, but it's not something a court will do. And I submit here, that the penalty they're looking for is the commercial equivalent of a pound of flesh, $1.3 million for a $175,000 breach. I'd urge this court to follow the sage advice of Judge Ginsburg. And it's nice to say you're a commercial party, you agree to it. But the law, for hundreds of years, going back to England, it's in the restatement of contract. It's been recited by Chief Judge Marshall. It's been recited by this court at least 5 or 6 times for 150 years, is what it is. There's no basis to change the law. It would be terrible policy to change the law. It's been approved by the legislature in the Uniform Commercial Code for commercial contracts, and for that reason, I would urge this court to affirm. Thank you.
Thank you, Mr. Lieberman. Counsel?
First of all, the facts show that Columbia was trying very hard not to declare them in default, just so we're clear. They missed a payment in May, Columbia didn't say anything. They missed a payment in June, Columbia didn't say anything. They missed a payment in July. They defaulted in July, August, September, and October, 4 months before we sent them a notice to cure. And then they didn't cure.
But they did offer everything that was due before the last payment was due.
They did offer
I mean, you had put it in installments. I doubt that's for the benefit of Columbia as opposed to the benefit of D'Agostino, which was in a distressed state. So
They did.
Why isn't he right that there's something wrong if he concedes. You didn't have to accept it, but it's a factor to consider as to whether or not you can really look at this as a penalty.
Well, the assumption that Columbia set this up so there'd be a default and they would jump on the default immediately and try to recover the amount of the liquidated damages is just belied by the facts. We sat back and waited for 4 defaults before we sent them a notice to cure, and then they didn't cure, and then miraculously after we sued them, they came up with the money. It's a little unseemly also that we enter into this agreement at the end of May, and then a few months later, we're being told the agreement's unenforceable. Yes, sign the agreement. Thanks very much.
Well, they did pay the first 2
They did pay
significant
the first 2
installments,
payments.
correct? So they didn't from the get-go, they didn't come out of the box refusing to pay. And when you entered this agreement, you knew they were in a distressed state, so you knew, of course, that they're looking for that benefit, not to be in a continued tenancy that, unfortunately, by then, they're an icon, you're an icon, that they've already realized they cannot continue, and they're trying to deal with their staff.
But they
And what
agreed
might
to-
happen there. Let me just confirm, because you had said something I wanted, you heard me, I checked with him whether or not I had misunderstood the surrender agreement, so I just want to give you the opportunity. Did the outstanding past due rent before the effective date of the surrender agreement survive the surrender agreement? That is to say, were any claim against them for back due rent still viable?
Well, and our complaint in this lawsuit it seeks only the future rent.
No, I understand that, but I may have misheard you. I thought you said that the surrender agreement let them off the hook for the back rent, which was not the
no.
way I read it, so I just wanted to be clear.
No, the back rent was what they already owed us.
Yes,
was
no, I
what
know
we
that.
agreed to accept. A conceded liability that we had a right to judgment on, we
Yes.
agreed to accept that
Yes.
and let them walk away from the rest of the rent.
Yes.
But
So
once they
that's what I'm
defaulted-
saying. They owed whatever had been set out. Let's not talk about a breach of the surrender agreement. If they had paid on time, whatever they owed, but they also were going to pay you everything that they owed in back rent for the time that they had benefited from being a tenant on that property.
Right.
Yeah.
They conceded that they owed that amount of money. We said, just pay what you owe us, go
Yes.
away.
Okay.
And we'll
No, I
make
just
it-
wanted to clarify
Right.
that. I think I may have misheard you.
No, okay, thank you. I think the key component here is that we have to look at this whole agreement at the time it was made. And at the time it was made, they hadn't paid the back rent, and if they continued not to pay rent, we would have been able to sue them for those damages until we got a tenant and perhaps mitigated it, as well as the other costs of procuring a tenant. That was what we had at stake, and we gave that up.
But why
and gave them a
couldn't you have
discount.
calculated that in the sense at the time you entered this new agreement that your damages would be that? That if you violate this, if you violate the terms of this agreement, our damages will be what we would have gotten then.
Correct. And then-
Why couldn't that be the agreement? Instead, you liquidated it to be the maximum you could have gotten, right?
Right.
And wouldn't that account for your risk? Because if in fact you never had rented it for the rest of the term, that would have been your damages. But if you had rented it for a higher amount, we would have had maybe costs or some reasonable amount.
Absolutely.
So in the sense of not being able to calculate it, why couldn't the provision just provide you with that remedy?
At the bargaining table, that could have been the result, just as well it could have been the result that D'Agostino said.
No, but why couldn't you write that into your contract, that the measure of your damages would be a calculation based on what you would have recovered at a breach at that time? Your idea being, we're taking this risk that we're not going to rent, why wouldn't that cover you then for that risk? In the sense of, why isn't it calculable in that way? Because you could have written the damages provision to accommodate that.
Well, it wasn't calculable how long it was going to take us to find a tenant. It wasn't calculable how much free...
Right, but this would have given you essentially a time machine. So you would have gone back and you would have been there and you would have recovered what you would have recovered at that breach. So if you hadn't rented, in fact, you wouldn't be assuming the risk because they would owe you for that amount. If you had, it would be mitigated.
Well, I think that's still the case, Your Honor, but you still have to find that the penalty here is the difference between the amount we agreed to accept and the amount of our actual damages. I mean, they could have negotiated a mitigation clause into the settlement agreement. They could have said, our damages will be the full amount of the future rent, but you have to mitigate.
Well, we don't know what your negotiations are, so we're just working with the language that you agreed to and adopted, right?
Right. So at the time we signed that agreement, not knowing what the future holds for that property,
Sure.
I don't believe the damages were ascertainable to precise measurement.
If I may ask this, because I asked him, is it a factual finding by the appellate division? Is it a mixed question? Is it a decision on the law?
It's a question of law. This court has repeatedly held that whether liquidated damages is a penalty is a question of law.
No, I'm sorry, whether or not it was ascertainable. I know that other question, but this sub-question, whether or not it's ascertainable. At
Well,
the time of that you signed the surrender agreement.
Oh, I think if there's a question of fact.
That's a
We move
question.
for summary judgment. They claim that it's a penalty. If they've established some question of fact as to whether it's ascertainable or whether it's grossly disproportionate to the actual damages, then under Van Duzer, we clearly need a hearing. I mean, at a minimum, if those are questions of fact.
But I'm saying, when the appellate division reached that determination, was that a finding of fact? That's what I'm
No,
asking you.
that's not a finding of fact. There was no facts presented to the appellate division for it to render a finding of fact. There was no testimony, no
So
hearing.
what is it based on? What is it based on?
I think they based it, they ruled it as a question, they ruled it as a matter of law that the damages are ascertainable based on this record.
Okay.
And we don't think that's supportable in this record. And at a minimum, if they raise the question of fact, again, under Van Duzer, I think at a minimum, we're entitled to a hearing where a court can then make factual findings as to what was ascertainable at that time and what our actual damages were in order to determine if they're grossly disproportionate to the amount in the agreement. I think at a minimum, we're entitled to a hearing. But I think as a matter of law, we would suggest this court, as a matter of policy, should not be interfering where the parties have set their expectations in a clear, unambiguous writing. It's a settlement agreement of a litigation or potential litigation. This court has time and time and time again enforced settlement agreements unless there's something particularly egregious. This court ought not to be setting the bar that the courts are entitled to step in. Landlords are not going to make deals with tenants if they think the discounted amount that they provide is going to be the maximum amount of their liability, even if the tenant defaults. It sets a bad precedent out there for people who want to make arrangements among themselves and not fear that courts are
Well,
going
all
to
we
come in.
need to do is decide whether this is a penalty, not whether some lower number would not be a penalty, correct?
Correct. If this is a penalty, then we're entitled to our actual damages, which is yet
Thank
to be
you, counsel.
determined. Thank you.